To the 2018 Ohio Center for Law-Related Education Moot Court Competition. I'm Ann Yeager from the Supreme Court of Ohio's Office of Public Information. We are about to watch two high school teams from across the state present oral arguments in front of a panel of judges arguing as appellants and appellees in the fictional court case United States versus Cado Toste. The purpose of moot court is to simulate the appellate court process, which is very different from the trial court process most people may be familiar with. An appellate court hears appeals that come out of a lower court's decision. Appellate court cases are heard by a panel of judges instead of a single judge and jury. Attorneys in appellate cases do not interview witnesses or present evidence. Instead, appellate court proceedings consist of legal briefs and an oral argument. The case being argued before the moot court judges today is called United States versus Cado Toste. In this scenario, Cado Toste, an 18-year-old high school student, has been convicted of providing material support or resources to a designated foreign terrorist organization after he began curating and spreading messages online promoting the activities of a violent environmental group called Oakenfist. Toste is appealing his case to the Supreme Court of the United States, which will consider the following questions. 1. Did Cado Toste meet the principal elements of the crime? Did he knowingly provide material support or resources to a foreign terrorist organization? And 2, if he did provide support to Oakenfist, are his actions nonetheless protected by the First Amendment, and therefore is the statute as applied to him unconstitutional? Oral arguments for the 2018 moot court competition are about to begin in room 106 of the Thomas J. Moyer Ohio Judicial Center in downtown Columbus.
Court will now hear arguments in the case 2017-9999, Cado Toste, or United States versus Cado Toste. Petitioners? Please.
Associate Justices, may it please the court.
Oh, I'm sorry, I forgot something. The TV people. They want us to introduce ourselves. Justice Patrick Fisher of the Ohio Supreme Court, starting at my right.
I'm Sam Peterson, Deputy Solicitor at the Ohio Attorney General's Office.
I'm Mike Hendershot. I'm the Chief Deputy Solicitor, also at the Attorney General's Office.
Tiffany Carwile, Assistant Attorney General.
Benjamin Tracy, Staff Attorney, 10th District Court of Appeals.
Sarah Stafford, Senior Judicial Attorney for Chief Justice Maureen O'Connor.
Nikki Baczynski, Assistant State Public Defender at the Ohio Public Defender.
Now you may proceed. I'm sorry.
Good morning, Chief Justice, Associate Justices. May it please the court. I, Code G1, along with my co-counsel, have the privilege of representing the appellant, Cado Toste. In this moment, I would like to reserve a 2-minute block for the rebuttal speech that my co-counsel will be given. During my time before the court, I will be addressing whether the lower courts erred in finding that there is sufficient evidence to convict Cado Toste under the material support statute. It did. We respectfully request that this court reverse the decision of the lower court for the following 2 reasons. First, because Toste did not have the appropriate mens rea to be held liable to this statute, and second, because he did not provide material support. But first, Toste did not have the appropriate mens rea to even be held liable to this statute. And this is because there's no evidence that he has the knowledge that it was a terrorist organization, nor that his acts would result in furthering the terrorist cause. So it is not enough that Oakenfist is declared a terrorist organization if he did not know that they were a terrorist organization, and it is irrelevant what he did or did not do if he didn't know. So we have to turn to U.S. v. Stewart, where the Second Circuit Court ruled that there is sufficient evidence to indicate that the defendant in this case knew that he was working under a terrorist organization because he was a religious leader of this terrorist organization. But in contrast to today's case, we do not have sufficient evidence to prove that Cado Toste knew that they are a terrorist organization because he is simply a high school student.
Did he not pledge his allegiance to Oakenfist when he promised that he would post twice as many of his of content, and then posted twice as much content?
This isn't a pledge of allegiance. This is him simply telling them that he will support them, which is protected, does not fall under this statute.
So it's okay to say, I will support Al-Qaeda and then do something that they want, and that's not enough.
If it is support, it does not fall under the statute. But if it is material support, meaning if it is under the direction and if it is critical to a plan of the terrorist organization, that makes it material support. And because Cado Tost did not do this, he did not provide material support. And that leads me into my second point. Tost did not provide material support to Oakenfist. And this is because the lower court found Tost guilty of providing material support as he provided personnel. And material support is defined as property and services. And under services falls personnel.
Property and services?
Property or services.
Okay.
And under services falls personnel, which is when you look at the run of cases, when an individual is crucial to a plan, one specific plan of a terrorist organization.
Counsel wasn't, when Tost volunteered and agreed to be the curator, and that is a plan for them to get their message out, get their torture videos out, so wouldn't he be crucial to their expansion of their body of believers or followers?
Though he helps their social media presence, this is not material support because it doesn't help one specific plan. Because in order to evaluate what he does, you have to look at the run of cases. So just to name a couple, in US v. Augustin, the defendants took photos for Al-Qaeda of a building they were planning on attacking. And US v. Stewart, the defendants engaged in
Counsel, that's all well and good, but those are the lower courts, and we're here to establish a rule, and just because that's what the lower courts have done, that's not what we should do. So why is that the rule that we should write, that you're currently advocating?
Although we are not bound to follow what the lower courts provided, when you see a large number of cases that the lower courts evaluated, and they evaluated that the defendants in them provided material support because they are critical to a plan, we should also realize that these judges and the people involved in this case knew what they were doing as well, and we can take guidance from them because such a large number of them come to a consensus on this point.
Are you saying, go ahead.
Did they explicitly come to a consensus on the point that you're trying to get us to adopt, or was it just that the facts of those cases happen to have individuals, the defendants, who were part of a specific plan?
Well, although they didn't come to one exact consensus, all of them did come to the same conclusion at the end, which indicates that with so many situations following under similar facts, we should also rule in a similar way. So when you look at US v. Augustin, US v. Stewart, US v. Farhane, and US v. Al-Shanawi, all of the defendants in these cases are critical to a plan of the terrorist organization, of which Tost is not. So,
Well, didn't Tost call on friends of nature to visit divine justice, and isn't recruiting part of a plan to develop the terrorist organization's agenda?
he did call on individuals to follow nature's divine vengeance, and the recruitment is a plan. It's not anything like the plan specified in the cases and in the run of cases we have provided. So when you look at these cases, all stand on the crux of whether or not the support was critical to the mission, and they all boil down to one specific plan. And this case does not boil down to one specific plan, so we have to conclude that Tost did not provide material support because he is not critical to the terrorist organization. And also,
If he wasn't,
It seems that you're asking us, and I'm curious where this comes from the statute, to say critical to a particular plan versus a course of action, a plan of action more broadly. Where do I find that? I mean, I understand you're saying the lower courts, the cases they've dealt with, have had that common thread, but where does that come from the statute itself?
it doesn't come from the statute itself, but all of these cases that I am citing are reviewing the statute and are trying to fill in any vagueness that may be brought up about it. So we have to evaluate these cases to find the details, and when you evaluate these cases, you realize that that material support is when you are critical to a plan.
Let's say you're right, and he has to be critical to the organization, if not a discrete plan. Didn't they say when they wrote him, you might be just the person we've been looking for?
Although that
And he responds enthusiastically, yeah, that's me.
Although that is said, he is still not providing personnel or material support because they are looking for him, and they do appreciate what he's doing, but because he isn't critical to a plan, it's not material support. And also,
Counsel, are you saying that if someone hires as a recruiter to recruit a bunch of people, but those people are going to go out and do multiple plans, multiple different things that may not be set in stone right now, but they're just recruiting people to later future use them, that's not covered by the statute because it's it's not specific to one plan?
Well, it's specific to a larger plan, so
And how is this not then specific to their whole plan of getting their message out and getting more followers and more people to, in their mind, to protect the environment?
it also doesn't fall under it because we don't have any proof that Toast is actually reaching an audience here. We just know he's creating these videos. So we can't say that he's actually helping recruitment if we don't have evidence of people joining because of him.
But we do know that they like what he's doing, right? And he says he's going to put out twice as many, right? And then he buys some equipment, right? And then they reimburse him for it, correct?
Correct.
Isn't that providing support?
That is not providing support because he is also acting independently, which means that he doesn't fall under this. So this brings me into my next point.
Why did he accept the money then?
He accepted the money because he is a high school student. What high school student wouldn't accept $300 if it was freely offered to him?
Counselor, you keep relying on the fact that he's a high school student. You said that in your opening. Well, he can't have knowledge, he's just a high school student. So is your argument that high school students are immune from prosecution under this statute?
Not necessarily, because there's no evidence that he does know. So if he was a high school student and there was evidence that said high school student did know that they were working for a terrorist organization, then they'd be liable under the statute. But because there is no evidence, we can't hold him liable.
Can't we infer that he knew they were a terrorist organization when he watched their videos that led to people's deaths in the name of a cause?
There's no evidence that he actually watched these videos. The only video that we know for sure that he reviewed is one of no torture occurring. So.
Counsel, there's statements in his emails that says that people say you're going too far, but that he disagreed. I mean, what else would it be that they're going too far except for their videos where they've kidnapped people, tortured them, and killed them?
We don't have evidence proving that, so we can't hold him liable to this statute. But
Isn't that a reasonable inference that we would need to side with the government on?
No, because it is the government's burden if it's beyond a reasonable doubt to prove this.
Yeah, but we're here after a trial and an affirmance in the Court of Appeals. So yes, the government had the burden at trial, but now the burden is yours to show insufficient evidence.
Well, there is insufficient evidence because we don't know that he had the appropriate mens rea because he is an 18-year-old high school student. So just because he is an 18-year-old...
It's fairly absolute. Like my colleague asked, right? Are you saying that there's only a very select few of 18-year-olds that could even form the appropriate mens rea here?
Well, because Oakenfist wasn't a widely known terrorist organization at this moment, I would say yes, if we're talking specifically about Oakenfist. And we know that Oakenfist isn't a widely known terrorist organization at this point because it had only been declared a terrorist organization 2 months prior to the interaction between Tost and Oakenfist. And it does not have the same reputation, the same name as ISIS or Al-Qaeda, so we have to take that into account and into the context when evaluating whether Tost knew that they're a terrorist organization.
I have a question. Is it that he has to know that they're a terrorist organization, or does he need to know that they've been designated a terrorist organization, and how does that affect your argument?
He has to know that they are a terrorist organization. So that doesn't change my argument because we don't have evidence that he did know they're a terrorist organization. But getting back to my point about how he was acting independently of Oakenfist. So if we turn to U.S. v. Augustin, the defendants in this case, their actions changed drastically after they aligned themselves with Al-Qaeda. So the defendants in this case aligned themselves with Al-Qaeda and afterwards took photos of a building that they are planning on attacking for Al-Qaeda because they are working under the direction and in the control of Al-Qaeda. But Tost's actions do not constitute as material support when comparing this case today to U.S. v. Augustin because his actions did not change after the oath and the content he produced didn't change after his alignment with Oakenfist.
I thought he increased the number of videos he was sending out, doubled it.
He did increase.
How's that not a change in activity?
Because it's the same content. He was saying the same things and doing the same thing before and after. So Oakenfist told Tost, keep doing what you are doing. Before this interaction, Tost was working independently. We can all agree on that. But after this interaction, after they told him to keep doing what you're doing, that indicates that they wanted him to continue acting independently, and he did continue to act independently because he produced the same content.
Counsel, they specifically asked him to be the curator of their media. Then he doubled his efforts, and he bought a new camera. He used that new camera to tape himself viewing their videos and posted that. He made his own videos about how they need to take vengeance on the president. And that's how, maybe it's a similar message, but those actions are different than what he was doing before, are they not?
Well, looking at the part about your question about the curator of content title, he wasn't specifically working at Oakenfist social media. He didn't have access to their account, meaning that his actions were not specific to Oakenfist at all. Additionally, anyone who produces anything on social media could be labeled a curator of content because they are creating content. So this title doesn't indicate anything about him providing material support to Oakenfist. Furthermore, when you turn back to U.S. v. Augustin, where the defendant's actions changed before and after their interaction, this did not happen with Tost. And furthermore, Tost is the same thing before and after he interacts with Oakenfist, and meaning that his action is independent of this terrorist organization. And even if we say that he provided material support, it is not enough to hold him liable under the statute if we cannot prove that he was acting under the direction of Oakenfist.
But even under U.S. v. Elshenway, wasn't financial support from the home country enough?
Well, in U.S. v. Al-Shanawi, that case is different from the one today, and that is because the defendant was critical to a plan of the terrorist organization because he used the funds given to him from ISIS to purchase communication devices and then tried to convince others to join ISIS as well.
Well, didn't this fellow, in effect, contribute funds by buying himself nicer video equipment and then use that nicer video equipment to try and convince people to take up Oakenfist's ideals and take up their crusade? Now, I know he was reimbursed, but he didn't know when he bought the video equipment that he was going to be reimbursed. So isn't that, at least initially, a material contribution?
Well, his video equipment he didn't use just to film the reaction videos. He also filmed other videos at the time. So we can't just say that him buying this video equipment means that he provided material support because he used that video equipment for other reasons. And also the US v. Al-Shanawi case is different because he purchased the communication devices with the sole intent of helping ISIS, where in this case he didn't. And
I want to go back, so let's look at the Augustin case, but change the facts a little bit. So they bought a camera to take pictures of the federal building, but what if they also then use that camera for their own personal pictures, take family portraits? Since there's a dual purpose of they're taking photographs, and what, is that no longer material support if they're using it for more than one thing?
Well, that hypothetical is different than the situation we're dealing with today because those photos, as I established earlier, were critical to a plan of the terrorist organization. And because Tost is involved in no such plan, it is not relevant to today's statute. And for these reasons, I respectfully request that this court reverse the decision of the lower courts.
Thank you. Yeah, please. G2? Please proceed.
Chief Justice, Associate Justices, may it please the court. I, Code G2, along with my co-counsel, have the privilege of representing the appellate, Cado Tost. In my time before the court, I will be addressing the second issue of whether the lower court erred when it held that Cado Toste's actions were not protected when he spoke in line with the beliefs of Oakenfist. It did. And we respectfully request that this court reverse the decision of the lower court for the following two reasons. First, Cado Toste's speech was not integral to criminal activity, and therefore it is protected under the First Amendment. And second, because he was acting independently of the Oakenfist organization. Now, the First Amendment states that Congress shall make no law abridging the freedom of speech. And this means that no law can be made abridging speech based on its messages, ideas, subject matter, or content. In fact, the only standards which we have today on the ways in which speech may be abridged are given to us by Bradenburg and Stewart, which is that speech provided in Stewart, that speech, which is the very vehicle of a crime, is not protected, and provided in Bradenburg, that speech which is meant to produce imminent and lawless action is also not protected. And Cado Toste's words do not meet this standard. In fact, the only case of which we have of things that Cado Toste actually said was his comment about calling on friends of nature to visit divine vengeance. And
Did
if
he
we,
call for the choking of the president?
it said for Cado Toste calling on friends of nature to visit divine vengeance on the crooked president. It never actually specified any action for which the people to give. And furthermore, if we look back to the Bradenburg standard, we can see that it said that the mere abstract teaching of the moral propriety or even moral necessity for a resort to force and violence is not the same as preparing a group for violent action and steeling it to such action.
Is it your position that this is a pure speech case, that there's no conduct involved in your client's conviction? Are you saying that his conviction rests on nothing but speech?
No, I'm not. In this case, we're looking at, the matter of whether or not his speech was integral. It's a matter of whether his speech, in the standard also provided to us by Bradenburg, is the matter in which his speech crosses the line from ideas to overt actions.
Right, but Brandenburg is a pure speech case, right?
Yes.
You can correct me if you think that's wrong. Okay, but you're not saying your client's conviction rests purely on speech. There's some conduct component there?
No, I'm saying that the controversy and the argument we are having here today is whether Toste's speech passes the line from just being pure speech, in which we look at it based on its context, and whether it crosses the line into being an overt action, which is not protected by the First Amendment, which it does not. And this goes back to what I was saying about the Bradenburg standard, about speech and the abstract teaching of moral necessities to a resort to violence are are protected under the First Amendment. And these types of speech...
There's no conduct at all involved in the defendant's conviction, that it is 100% speech? I was confused by your answer.
Well, in that case, we would have to look towards the Holder standard, which is that when you're dealing with conduct which can take the form of speech, in that case, you look at it based on its content. And while going back to the Bradenburg standard of what he was saying in this case, it is protected because it is his idea of divine vengeance and his veneration and respect for the environment and the moral necessity for its protection is akin to the same kind of language that one would see in chapters of the Bible or the Torah or the Quran, which talk about the moral necessities for violence,
But
which
isn't
we can
this
all agree.
more than just a moral necessity case? So if you take his speech and you combine it with the videos that he's watching, and presumably because he's watching the videos while he's also speaking, don't they together incite people to imminent violence? Because he's saying, we need to, friends of nature need to take action, and then you see these other videos of what he means to take action. So doesn't that cross the line when they're taken together?
No, because we actually have no evidence other than the one specific video of what he exactly was sharing with the world. And this video was only shared, or this comment was only shared with a video of a person who appeared after they had been presumably tarred and feathered, which means that there was no actual violence showed on this video that was shared with this comment. And furthermore, Toste wasn't just sharing Oakenfist content. As it states in the evidence, he was also sharing reviews of some other videos, and we don't know what those videos could be.
So is your position that being tarred and feathered is violent if you see it happening, but the after effects does not depict violence?
No. What I am saying is the fact that the fact that there was no actual torture and no actual violence shown on the video in which this comment was posted with means that you don't have enough...
Wait, if I show a video after someone has been beheaded and I urge people to bring that result about, you're saying because the violent act itself is not depicted, that is different? That that's not sort of an imminent incitement?
Well, a beheadment is different than a tar and feathering. Tar and feathering, historically speaking...
Sure, but I'm just trying to probe the principle that you seem to be articulating, which is if the act and its result, if the act isn't shown, but only the result, that is something we can distinguish.
It is distinguishable in this case because to be tarred and feathered, it's not something that could actually bring death upon a person. It's, if anything, more of a humiliation tactic
I would
than
think
an
that would
actual
depend on
method
how
of killing.
hot the tar is, wouldn't you say, counsel?
I'm sorry?
I said I would think that would depend on how hot the tar is, wouldn't you say, counsel?
Well, historically speaking, there has never actually been a recording of somebody who has been killed as the results of a tar and feathering.
So it's appropriate, so it's not quite as bad if they get third-degree burns all over their body. That's just humiliation, that's not torture?
It does not reach the degree of torture and an incitement to violence as something like a beheadment would.
You have to kill someone in order to be torture and to be incite violence.
Not necessarily. It's just that in this specific case, the tar and feathering where the man was still vocal, he was still conscious, he was still, he wasn't physically hurt enough that he was lying inert on the
If I
ground.
pull someone's, everybody, if you have a person that has no teeth in their mouth, they've all been pulled out, and he's crying on the floor with blood hanging out of his mouth, that's not sufficient, that's not torture.
I'm not saying that that isn't torture, but what I am saying is that in this specific case, what we have as the content of the videos accompanying with the message is not enough to say that this was him inciting the people to violence. And furthermore, he never actually gave an explicit command or an explicit request for the people to continue these actions. He just
What I'm
said
hearing
divine
from the
vengeance.
bench is confusion about how you can say that if I tell people, visit nature's divine vengeance upon the president and his supporters, and at the same time show a video of a guy who has clearly been tortured, however you want to call tar and feathering, I would say it's torture. How is that not, look, here's an exhortation, and here's an example of exactly what we think you should be doing? I mean, how is that not an incitement to imminent lawless action?
Well, this is a point where we can look towards other cases, and I believe it was U.S. v. Ahmed, where part of being able to pass this Bradenburg test of producing imminent lawless action was that he was very specific. He gave times, he gave place, and he gave specific actions of what he wanted people to do on behalf of this terrorist organization. And how also, if you look, moving on from this.
Before you move on, I just want to clarify something. We've spent a lot of time talking about incitement and Brandenburg. I just want to make sure I understand your position is, if I disagree with you about that, do you lose? Or you're saying that everything comes down to whether there is speech or not? Or are you saying there's, again, this is back to the conduct question I asked before. Is your entire case about whether it's a Brandenburg-type case? Or, so are you disclaiming any conduct?
Well, this is actually what goes on to my next point, which is analyzing it in Holder under the idea that Toste was also not providing any sort of specialized service to the Oakenfist organization. Now, Holder holds that conduct can take the form of speech, and when it does, you look at its content. Now, in that case, the person has to be imparting specialized knowledge. And all that Toste was doing was regurgitating information that was already available on the internet. It was nothing.
He did a review of one of the films, though, right?
Yes, but.
So he's giving his view.
Yes, but.
So isn't that taking it a step further than just forwarding on some video?
Yes, but adding his own opinions to what was happening was no different than what he was already constitutionally protected and doing prior to his conversation with Oakenfist. Because at that point, he was also commenting and giving his reactions to these videos and things.
So a video of somebody choking on oil, saying, it's a good thing. That's not providing nonviolent, non-terrorist activity? I'm quoting from Holder.
Well, it is no question that his actions were protected prior to what he was posting, prior to his conversation with Oakenfist. And that was among the nature of what he was doing. And that was protected under the First Amendment.
Why do you say there's no question there? I mean, it just wasn't tested because he was prosecuted under this particular statute, which requires a terrorist organization to be part of it. But that doesn't mean, how can we be sure that it was fully protected before his contact with Oakenfist?
What he was doing was not illegal because, as I was saying earlier, the nature of what he was saying was not meant to incite imminent lawless action. Now, furthermore, as I said earlier, because he was not providing any sort of specialized information or specialized service to this Oakenfist organization, and because he was also not inciting imminent lawless action, he does not reach the Stewart standard of actually posing a threat, and therefore by his association with the Oakenfist organization. And now I'd like to move on to my next point about the fact that Toste was also acting completely independent of the Oakenfist organization. Now, mere membership to a terrorist organization is not illegal. It is by the standards set in Nagy and El Shinawi where we see that it is when you further the efforts of a terrorist organization that one's actions become illegal. However, Holder
So you
also—
comment publicly on, and positively on the terrorist organization's video of somebody choking on oil being put into them. That's not providing support.
That is the difference between advocacy. That is actually, that's not material support, that's just advocacy, which—
Isn't that action? Isn't that, don't you have to take an act, perform an act to send that out?
No. In the case of action, it would be an overt action, which is providing something that would have an actual consequence. Your speech must have a consequence in for it to cross that barrier of an idea to an overt action and to thus be unprotected.
Counsel, if I may, your co-counsel has argued that this does not run afoul of the statute, and you've argued that this is protected by the First Amendment. And as I understand it, either one would provide a basis on which to reverse the lower court's decision. Do you have a preference, should we rule for you, on which basis we should rule?
Well, I see that my time has run out. May I briefly answer your question?
Go ahead.
Well, in this case, this First Amendment argument functions entirely under the assumption that it is proven that he had provided material support, which he did not, and as my co-counsel already proved. So essentially, this argument is, her argument is sufficient to prove that Cado Toste, that the decision of the lower court should be reversed.
Thank you. D3, please.
Good afternoon, Your Honors. Before my time begins, I would like to confirm that my student code is D3. I, along with my co-counsel, represent the respondent, the United States, in this case. I will be addressing Issue 1, and my co-counsel will be addressing Issue 2. Chief Justice Fisher, may it please the Court. The first issue before this Court is whether Cado Tost's active support of a designated foreign terrorist organization violated 18 U.S.C. 2339B by providing material support to a foreign terrorist organization. The second issue is whether Mr. Tost's actions were protected by the First Amendment to the Constitution of the United States. In addressing the first issue, it is our position that Mr. Tost's actions violated 18 U.S.C. 2339B, and we respectfully request that this Court affirm the decision of the Court of Appeals for the 13th Circuit for the following reasons. The 11th Circuit explained in United States v. Augustine that when reviewing a case for the sufficiency of the evidence, the Court must review the evidence de novo. The Court further explained that the Court must view the evidence in the favor most favorable to the government and make all reasonable inferences and credibility choices in the government's favor. In United States v. Stewart, the Second Circuit explained that the defendant carries a very heavy burden. In the case before us today, the petitioner violated the statute, and there was sufficient evidence presented at the trial to support a conviction. Before I begin, I want to address some issues that were brought up on opposing counsel's arguments. She made mention that there was an insufficient evidence, and one of the evidence presented was the fact that he did not have the appropriate mens rea because he was a high school student. Now I'm going to read a section of the statute which clearly states that to violate the statute, a person must have knowledge that an organization is a designated terrorist organization, that the organization has engaged or engages in terrorist activities, or that the organization has engaged or engages in terrorism. Your Honors, it is clear that Mr. Tost knew that the organization engaged in terrorism because he shared videos of acts of terrorism that were posted by Oakenfist.
Well, counsel, I hear you. Let's assume you're right. I'm not agreeing. Just assume you're right. Where was the coordination? Where was the joint action with Oakenfist?
Well, the joint action was in the emails between both Oakenfist and the petitioner.
Emails are action?
Well, emails started and then
Emails aren't
actions
speech?
proceeded. Again, sorry?
Emails are speech, aren't they?
Yes, Your Honor.
They're not action.
No, sir.
Okay, so what's the action? What's the joint action? What's the coordination?
Okay, Your Honor, it started with the emails, and then the actions followed. In these emails, Mr. Tost decided to dedicate himself to the work of Oakenfist by offering himself to curate their online content. And he agreed to curate the online content, and he then again followed the orders that were given to him by the designated foreign terrorist organization by promoting their message and their activities through
Counsel, do you
social media
agree
networks.
with your friends on the other side that the mens rea requires knowledge that the organization has been designated, or do you read the statute differently as to the mens rea of what the defendant must know?
Well, as I just read, the statute clearly says that they must know that that the foreign terrorist organization engaged or engages in acts of terrorism, so I'm going to go with what the statute says. However,
I'm not sure right, I guess I can see the same words. I'm just curious what, if you agree, your friends, what I heard them say was there must be knowledge, the government must prove knowledge on the part of the defendant that the entity had been designated by the U.S. government as a foreign terrorist organization. Do you agree with that, or do you think that the mens rea can be satisfied by mere knowledge that they conduct terrorism or terrorist activity?
if we're going by the statute, no, I don't agree with my colleagues on the other side. Now, if you're a member of this august body that would disagree with this, even if you don't agree that Mr. Tost had the mens rea, you must agree that he must at least have had some knowledge of the fact that Cado Oakenfist was a foreign terrorist organization because, as I mentioned earlier, you must view all of the facts in light and most favorable in the government's favor.
I have a question for you, counsel. Let's say that Mr. Tost did everything that the facts say that he did, except he's never contacted by Oakenfist. So even though they don't contact him, he buys a video camera, he increases his social media posts. Does he have a legal problem in that case?
Are you asking if he had a legal problem if there was no contact between him and the
Yeah, if they never emailed him, but he did all the same things, and he doubled his social media postings, and he commented on videos, and he called for divine vengeance, etc. If he did all of that, but they just never contacted him.
If we're looking at this solo case, I would have to agree that his actions would be covered by independent advocacy because he did not agree to work on behalf of a foreign terrorist organization.
So why does the fact that they expressed to him that they like what he's doing,
Because he was working.
why does that alter the case? Just their approval turns what would otherwise be protected conduct into a crime. Is that the position you want us to take?
Well, Justice Tracy, he was working under the direction of the foreign terrorist organization. That's why that is different from the case I just presented to you about there not being any contact between him and the organization.
Well, let's play off Justice Tracy's question and say there was contact, except instead of a private message, they left a comment on his video, and they said the exact same thing. Keep up the good work, and we know he likes their post, and so he liked it. So that's not quite what Justice Tracy is having, but it's not what you would have here. Would he then be working under them? Because they would have told him, keep it up, and he would have kept it up.
I would agree with that he would be still working under the direction of the foreign terrorist organization because of the message. Because the message was private, doesn't have anything to do with him working under the direction.
This exchange of speech, really. I like them, they like me. That's enough to satisfy the statute.
No, it's not It's not the speech, it is the actions that followed. I'll give you an example. If I went to a Reds game and simply said, I like the Reds, that doesn't make me a Reds player. If I sign a contract and commit myself to becoming a Reds player, that is the action. In this situation,
What contract occurred here?
Yeah.
a contract occurred when he agreed to work for Oakenfist in terms of being the coordinator or being in terms of coordinating their online content.
What does that mean exactly? Maybe I'm showing my age. What does it mean to be an online curator?
Well, I would make it similar to a museum curator. A museum curator is responsible for organizing exhibits at a museum. They are responsible for placing them in their respective locations and also describing
So
them
was
in whatever
Tost
location.
organizing things on servers that Oakenfist owned or spaces that they were controlling online?
No, in fact, he was doing even more because what he was doing was using the World Wide Web, which is far more reaching than simply Oakenfist servers. But what he was doing was organizing and posting and reposting what Oakenfist...
Or was he organizing it on, Ford Motor Company has a web space, and if I organize stuff on there, I'm probably working for them. Where was he organizing this information? Where was it? If I went onto the web to see what he was organizing, where was it? If I looked at it, what would I think it was associated with? Was it his website, his social media presence, or Oakenfist's, where he was doing this curating?
Well, I would say it was a joint coordination between
But where
the two.
was it? Yeah, I know how you want to characterize it, but where was it? Where was it organized?
It was on his Facebook page, which is far more reaching because he was reaching an audience that Oakenfist was not reaching, particularly because they were in a foreign country, whereas he is in America, and he's reaching a far greater audience than a foreign country in another continent would be reaching.
Wouldn't his speech, his actions, have, under U.S. v. Abu Jihad, have to cause someone to commit an act for the statute to apply?
Yes, Your Honor.
What act occurred after he put something online?
Now, there is no evidence to suggest that there were actions that were done, illegal actions that were done following his posting of those tweets or posts from Oakenfist. However,
is it no harm, no foul then?
however, because the record does not indicate, that doesn't mean that there are not situations. Oakenfist had become a very violent organization, kidnapping supporters of the president, and other individuals who were somewhat sympathetic to President Strickland's environmental policies. So there was a trend.
Counsel, if there is no evidence, though, of that, and you say that it is a requirement, doesn't that mean that there was insufficient evidence for an element of the offense, and so we should side with the petitioners?
I would disagree with that characterization because we must remember that we must review the facts in the light most favorable to the government,
There
even
must
though...
be some facts to shine that light on. I guess I heard you saying there weren't facts of a consequence. So is that right?
I mean, we've already seen facts of what Oakenfist activities included. Violent acts of terrorism that they posted, and Mr. Tost, the petitioner, was reposting those violent acts. And so you can only assume that actions were done following afterwards.
Is assumptions enough for a criminal conviction?
No, assumptions are not enough, and I do understand that your decision will have a nationwide effect, and so what you decide on this case will affect many other cases following. But we must look at the evidence and what is here today, and we can see that Oakenfist had already had acts of violent acts, and that those would continue as they had already done.
Well, you agreed with the Chief Justice that a act had to have occurred based on the defendant's conduct in promoting Oakenfist, but then you said there was no act that occurred. So I don't understand why we're here then, if that's the case. I'm confused.
I think what act are you referring to? I would agree that there was an act with Mr. Tost, the petitioner, acting in conjunction with the organization. Now, when I said that there was no act, I said that there was no act of violence, but we can look at the evidence most favorable to the government and say that there possibly could have been cases of violence, even though the record does not clearly indicate
Counselor,
that.
do you have to prove that? Under the statute, do you have to prove that there was an act of violence following Tost's coordination with the terrorist organization?
Under 18 U.S.C. 2339B, there is no provision in here that indicates that we must do so.
So what then, I'm sorry, Joe,
Nope.
what part of the definition of material support are you hanging your hat on then? Like, which phrase or words do you want us to focus on to connect the facts that we have here?
Well, he provided service. He provided material support in the form of service and personnel, and that was what he was convicted of in the lower court.
And what are the services, what would you say are the services? And I mean, the personnel is obviously him. What are the services?
His service was to curate their online content and promote and advance the agenda of a foreign terrorist organization.
So it sounded a minute ago like you agreed that as a result of his, let's call them inspirational activities, someone else had to actually be inspired and carry out some sort of violent event. That sounded to me like that was what you were agreeing to. Did you mean to agree to that?
No.
Okay.
I'm more so saying that the statute doesn't clearly state anything about there being a need for violence to come as a result of the post. However, the record does not clearly indicate whether that happened or not, but I don't believe it is relevant to the issue at hand today.
I'm concerned about a limiting principle to your definition of services. It seems like you were saying in response to earlier questioning that because Oakenfist is in another country and Tost is in the United States, when he, by just speaking on Facebook and so forth, is providing them a service because they don't have the same access to online space in this country. But doesn't that make anybody who speaks in favor of an entity that's outside of the country, when they're speaking inside the country, possibly caught in the net of this statute?
No, I was more so speaking of the fact that he was offering them a wider base than they probably would receive in their own country. He
By
offered them.
speaking, that's what I'm saying. Doesn't that sweep in anybody who does a similar, who simply is giving the thumbs up to content that started overseas, and now by liking it over here in this country, that you're saying that satisfies the statute? I'm a little concerned that has no endpoint.
Speech is protected. However, when the speech turns into actions, that is when it becomes illegal. His speech about supporting Oakenfist is entirely okay for him to have.
What was his action then?
His action was joint coordination with the foreign terrorist organization, committing himself to curate their online content. That was the action. His speech, I would agree with my colleagues on the other side, that was perfectly acceptable, but his actions were not. And for these reasons, we respectfully request that you affirm the decision of the Court of Appeals. Thank you.
Thank you.
Before my time begins, I would like to confirm my student code is D4 and that I am addressing issue 2. I represent the government. I'm here to argue whether or not 18 U.S.C. section 2339B is constitutional as applied to the facts of Cado Tost's case. Now, I would first like to recognize Justice Henderson's discontentment that you expressed on opposing counsel's argument about lower court decisions. They're all in well, but they're lower court decisions. So I'd like to turn to something that this court is bound by, a decision they released in 1969 in Brandenburg v. Ohio. Brandenburg v. Ohio set forth a two-pronged test. Now, my colleagues on the other side got right the first prong. Did Cado Tost incite imminent lawless action? But they neglected the second prong, and that second prong is whether or not that imminent lawless action is likely to occur. If it is, then the prong is met. Cado Tost did incite imminent lawless action. He incited imminent lawless action when he recorded himself
giving speeches, calling on others to visit nature's divine vengeance. Nature's divine vengeance being the characterization of what Oakenfist was doing. Join Oakenfist. And to elaborate on what my co-counsel was interpreting from the facts, there's nothing in the record to suggest that anyone did act upon what Cado Tost did. We don't have that in the record. It's not available. But we do have in the record what platform that speech was made on. It was made on both Facebook and Twitter, a global, limitless platform. In addition, we cannot neglect the fact that the actions and videos made by Oakenfist have no impact. They do have impact. Cado Tost supported them. Cado Tost saw that and decided to go as far as to spend his own money on a camera because he was that influenced by it. How can we reason that it won't have the same effect on somebody else, especially on the platform of Facebook and Twitter that Cado Tost allowed for Oakenfist to have by sharing more of their content?
Let's talk about a more recent U.S. Supreme Court case. Let's talk about Holder, right? Didn't Holder find that speech is not protected only if it provides a specific skill or specialized knowledge, correct?
Yes, Your Honor.
So where's the specific skill or specialized knowledge?
Your Honor, here, the skill and specialized knowledge is the fact that Cado Tost went forth and did this frequently, and that's the skill aspect of this. He was posting these things frequently, and the commitment is...
But aren't there billions of people on Facebook and Twitter?
Yes, Your Honor.
So it's not that specialized, is it?
It's the fact that he was working in coordination and at their direction.
But how does that make it special?
What did they tell him to do specifically? What did Oakenfist tell him to do?
Curate their online content. And he did exactly that. Matching my co-counsel's definition, a curator is designed as someone that organizes information, chooses how to describe those, how to make an art piece in an art museum the most impactful for the viewer, that being the skill, and Cado Tost executing that skill, as he chose to not only retweet and post things, but realized that videotaping speeches...
So he didn't decide what was posted on the Facebook, or on Oakenfist Facebook, that he then reposted or retweeted or whatnot. He didn't decide the original content. Like if you're a curator of a museum, you decide the original content that's in that museum. He didn't decide that. So how is that a specialized skill just to send it back out into the universe?
Well, Your Honor, with the curator in the museum, they have a ton of artwork, but not all of it is on display at the same time. They choose what time of the year, when it's going to be put on display, what rooms it's going to be put on display.
But isn't every person using Facebook curating by forwarding one thing and not the other, liking this but not that? That seems like a very low bar for what, if you're talking about a curator of a museum, to being a curator of a social media space.
Not necessarily, Your Honor, because as an everyday person on Facebook, there's a difference between liking, posting things that you think are funny, and taking it on as a job, which is what Cado Tost did. He didn't look at each specific thing as its own entity. He saw it as a whole, an entire collection, an entire organization of what he was doing with the posts that were being made.
Sticking with your curator analogy, isn't it more like if a curator establishes an exhibit and then someone comes in and chooses which parts of that exhibit to post on their own Instagram? And so isn't Cado Tost more like the person taking photos on Instagram of something that someone else curated? Why isn't that the better comparison here?
That's not the better comparison because a museum curator is an employee and that visitor is not. They're visiting and doing that at their own free will. And Cado Tost, although he had his free will, he was acting in coordination with Oakenfist, and that's what makes it different from that analogy where the person posting it on Instagram isn't acting in coordination with the museum curator.
I want to start with, you started with Brandenburg. Are you saying that the entire conviction rests on speech?
Your Honor, the debate between actions and speech, it's a matter of speech-based actions. That's what's being prosecuted, and that was what was prosecuted 14 months ago. It's not the speech that's being prosecuted. It's the fact the speech is being used as evidence of his actions. And the only time speech can be prosecuted is when it meets the Brandenburg test of inciting imminent lawless action and that action to be likely to occur.
So then, is your co-counsel's admission that we don't have evidence in the record that anyone actually engaged in any of these acts relevant to the question for you, which is, are they protected by the First Amendment then? There's no evidence that it caused any problems or violence by anyone else. It's just speech.
Yes, Your Honor, that is relevant because you can't think of that as an admission. It is a fact. We don't know what's in the record. We don't know what influence this had on other people, what Cado Tost post had on other people. But we do know that it had an influence on him, post had an influence on him, and we can't search the world, the entire world, to look for other Cado Tosts out there. We only know the facts that are available to us. And going off of Chief Justice Fisher, I know you want me to look at Holder because that's a recent case from this court.
Let me ask you a clarifying question here, or what I hope is a clarifying question. Are you saying that what Mr. Tost did was speech, but not protected by the First Amendment because it fails the Brandenburg test? Or are you saying what he did was conduct, and therefore not speech, and therefore no First Amendment problem at all?
It's both, Your Honor, because both of them are inextricably intertwined. You can't look at this as a black and white situation because the conduct and the speech come as a package.
So what parts of it were, try to tease them out a tiny bit then, what parts of it were conduct so it wasn't just pure speech? What did he do that supports his conviction that was conduct-like?
Your Honor, the issue of conduct is the conduct is based on speech. So the conduct itself, that would be him recording videos of himself, that would be him reaching out to other people in the globe by reposting those things. But those things, those actions, are based on the speech, which is Oakenfist, which is
my act of typing an article, an op-ed, is that conduct because I'm using my hands to communicate?
Not necessarily, Your Honor. The speech is what you're typing. The conduct would be publishing that on New York Times versus a local news station.
Publishing a newspaper is conduct?
Your Honor, it's the platform on which it is published. That's what makes the difference. And here, by publishing it on Facebook and Twitter is what makes the difference between publishing it in something that doesn't reach the globe.
So if he just published it in his hometown newspaper, we wouldn't be here? If he did the same actions, he went out and bought a camera, he then took a video of himself and then posted that video on his local newspaper's website, are we not here today then?
Not necessarily, Your Honor, because that only goes to the Brandenburg test. And the Brandenburg test just has to do with criminalizing speech.
Doesn't the distinction that you're drawing here cause a pretty serious problem? I mean, if I write something that the government finds to be distasteful, I'm protected by the First Amendment, right? But when I do, under your view, the conduct of sending it off to the New York Times for them to slap on the front page, that they can regulate because that's conduct. I mean, that sounds to me like what you're saying, and that seems like a problem. Does that seem like a problem to you, counsel?
Your Honor, that's not what I'm saying, though. I'm saying we can't possibly separate the idea of speech and conduct because they are intertwined. Buying a camera, that is conduct. The speech he says on that camera, that is the speech, but they both go together perfectly. You can't separate them because they are intertwined.
If we agree with you and we can't separate them, then why would we not defer to calling it speech and saying it's protected by the First Amendment?
Because it can't be protected, as far as the speech being protected by the First Amendment, we must understand the statute as applied. Everyday speech about your local McDonald's or grocery store is perfectly fine. And even if it fails the Brandenburg test, we still have to look at that statute as applied. The language of the statute. Is that a violation as applied? And when we look at other cases, when we make Cado Tost's case analogous to other cases, we see that it is constitutional. For example, in U.S. v. El Shinaway, the district court reasoned that it was constitutional as applied. And in that case, El Shinaway received a series of payments. And they saw that as a turning point factor in their decision. Here, Cado Tost received payment for what he was doing. We look also at...
But he didn't seek payment, he got payment, right?
That's correct.
There's no evidence he sought it.
Correct. And
So isn't that really Oakenfist supporting him, not him supporting Oakenfist?
Well, Your Honor, in El Shinaway as well, the payments were unsolicited. But it should be remembered that the payment that Cado Tost received was attached to the message, "Keep up the good work," meaning that message was sent with the understanding that Cado Tost would do exactly as he were doing because that was part of the agreement. Now, I would like to hone in on this issue of money. Opposing counsel agreed with Chief Justice Fisher's characterization that this was a reimbursement. And that's exactly what it was. Because Cado Tost bought this camera to record his reaction to videos, to give speeches that called on others to visit nature's divine vengeance. And the $300 payment was a reimbursement for that. We can't look at it as Oakenfist supporting him because it was an exchange. He did a service for them. That is him acting in coordination with Oakenfist at their direction. And that's how it meets the standard, and that's why his conviction is constitutional. Now, I'd also like to rebut opposing counsel's argument as far as this likely to occur. She said, it can't be up for debate because this isn't murder. Tarring and feathering, the issue of torture, what is that? Your Honor, it's only lawless action. Speech that incites the imminent lawless action it makes likely to occur, trespassing on your neighbor's yard, is still illegal because it's still lawless action.
I want to focus on the word imminent. What's the evidence supporting the imminent nature of the offense, of violence? What evidence supporting the factor of imminent?
How to define imminent?
No. What's in the record supporting that any violence was imminent or lawlessness?
Your Honor, it's not a matter of the violence that was committed by Oakenfist as being imminent. It's that action was incited by Cado Tost that was imminent lawless action.
Okay, and what imminent lawlessness was in the record?
When Cado Tost published a video of himself giving a speech calling on others to visit nature's divine vengeance. And by calling on others to visit nature's divine vengeance, he was asking them to support Oakenfist as he has because he publishes these videos alongside the torture, the tarring and feathering, the murder of that Oakenfist.
Why isn't that inciting eventual violence as opposed to imminent violence?
Because of the frequency in which these things were published. It's one thing to say Hillary needs to go to jail. It's a different thing for the entire Trump administration to make repeated efforts several times a month demanding Hillary goes to jail because that suggests the imminent nature of it. Here, that can be made analogous to Cado Tost's case, where he was doing...
You're saying that those out there that are saying lock her up every day, they could be prosecuted, not under this statute, obviously, but you're here talking about the First Amendment. So those people are open to prosecution under some state statute. California writes a statute that says
No, Your Honor, because that's not inciting imminent lawless action. Would you like me to finish answering this,
Yes,
or
please.
would you?
Go ahead, answer his question.
Because that's not inciting that's not inciting lawless action at all. Lock her up. What if she really is guilty? She should justice. But, Your Honor, it's the matter of using that example to show the similarity with Cado Tost and the effect that repetition can have in regard to how likely something is to occur. Thank you.
Yes, rebuttal. G2. Okay. Please proceed.
I have a few points in rebuttals, Your Honors. First, with the mens rea component. By the standards set in Augustine, we have to review the statute of whether a person knowingly supported a terrorist organization as what a reasonable person would know or should have known. And in this case, we're looking at an 18-year-old boy. And all of us know that when we are on the internet, when we are on Google, when we are on Facebook, when we are on YouTube or Instagram or any number of social media websites, our experience on those websites is filtered by those companies. And therefore, we would reasonably believe that what we were seeing on these websites is something that is allowed to be there and is not illegal content and is not terrorism, which should be kept off of it. Now, secondly, our opposing counsel made 2 points about whether this was protected speech and whether it was unprotected conduct. And first, they directed to the 2-prong test set in Brandenburg. Now, they changed their opinions on whether they agreed that Cado Tost directed people to do imminent lawless violence. However, they treated this as an or test. And according to the language of Brandenburg, it has to be directed to produce imminent lawless violence and likely to do so. And as we stated on Justice Pfister and Justice Hendershock, there is no evidence that what he was doing was likely to produce anything, and therefore it also fails the Abu Jihad standard of consequent actions coming from what the person was doing. Now, furthermore, he was not providing any special skill under the Holder standard to be considered conduct, because also he was only giving general knowledge doing on a platform that anybody with a computer and an email address can use. Furthermore, their idea of an online curator versus an art curator does things that gets put into a museum on behalf of an organization. Everything that Toste did stayed on his own social media, and it was completely independent of their organization. May I briefly conclude?
Yes, quickly.
Because of their facts and because that everything they did was based on speculations, we respectfully request that this court reverse the decision of the lower court. Thank you.
Thank you. Thank you, and you should be proud of your teams. The only thing I'm going to say, I'm going to let the junior associate justices speak first is, and I put this on my scorecard, I'd be happy to have any of the 4 of you working with or before me. You should all be proud, and I'm sure your parents are. That was a great performance by all 4 of you. Not so much at the Ohio Supreme Court, but at the Court of Appeals level, you would have beaten that. All 4 of you would have beaten a lot of people that appear. So you should be very proud. I'm going to allow, let's see, most junior. No, it would be down there. And then we'll go back and forth, okay? Go ahead.
I thought you did an absolutely extraordinary job. Your style in particular was really amazing. It's hard to believe that you're all high school students. Are you seniors? You? Wow. I mean, really, really amazing. And none of you really seemed rattled by the questions, which is also very impressive. It's easy to have that confidence when you're sticking with your outline, but to have it when you're being really pushed hard. I don't think anybody went easy on you. And to still maintain your composure was just, it was very impressive. Congratulations.
I just want to echo all of those comments, especially Justice Fisher's, and I think I would go even so far as to say you could advocate before the Ohio Supreme Court for and I didn't get a chance to write comments on the back, and so I just wanted to give a couple for each of you, and I'll start in order. You handled your interruption at the very beginning very well. I know that could rattle somebody, and I especially liked how you synthesized all of the you had a theory of all of the different cases and how they fit together, and that's one of the hardest things to do sometimes, so I think that's especially well done. You got a lot of really tough questions on your first time around, and you handled those very well and didn't get rattled. And then I think your rebuttal was very good. You picked out, you can only do so much in rebuttal, and you picked out some of the key points that you knew you needed to address. And so that, again, thinking on your feet is very well done. Your pacing and delivery, I thought, was spot on. And one of the things you did that I really thought also I always strive to do is to pay attention to where the questions have been already, because you're not coming up to a cold bench, and you listened to what had already been asked of your opponents and then tailored your presentation to that, and that is just incredibly well done. And then the other thing is, you knew where you had to draw the line on public versus private messaging, and had you given up that point, it could have opened up a lot of other tough questions, and you stuck to that even though it could have been a difficult point. So that was a good knowledge of where to draw the line. And then finally, you also had synthesized the arguments of everybody. You're up there next to last. Everything's already been said, and you synthesized so well what the bench has said, what your friends on the other side had said, what your co-counsel had said. And again, the presence of mind, you can rehearse a lot of things and you can practice a lot of things, but that presence of mind is a skill, and it was spot on. So very well done, all four of you.
I would hire any of you, so that's a good sign. I can't say that about all the attorneys that I've seen argue. So more than anything, I think you all showed an excellent level of ease with the facts and the law. And so your ability to stand up here and have a conversation with the bench really helps inspire our confidence that you know the material. A lot of times cases aren't decided just on oral argument. But to the extent you can have that conversation and respond to questions easily, and that sort of thing helps us know that maybe the way we're leaning after reading the briefs and preparing, reading the case law is the way to go. So excellent level of preparation for all of you. And you saw me up here struggling with math. Because there's not allowed to be ties, it was very difficult. So excellent work.
I'm not sure what I can add to that. You should all be extremely proud of what you did. I think, to echo a little bit what Sam was saying, the Chief Justice of the United States has been fond of saying, your main job after the first person is gone is to show that you were paying attention to what was going on. And I really did see that in each of your presentations, as to, again, to steal what Sam was saying, to synthesize what had happened before. Because that's what oral argument is about, is not what you would plan. Very rarely does it go as planned. I can tell you that from doing dozens of these, where sometimes I really, really think I know what's going to happen, and I'm usually wrong. So the ability to adjust to that is, and especially rebuttal is certainly the acid test of that. And I was really impressed by all of you, the ability to respond on the spot. It's something that you can refine by practicing, but you can never quite practice it as it's going to happen in the moment. So I enjoyed doing this, so thank you for keeping this program going and bringing us such a fine performance.
Well, I appreciate the comments of my fellow justices. I would echo them. I'm actually kind of impressed that you say that rarely do things go as planned. I would even go so far as to say things never go as planned. That said, I think the greatest asset that a lawyer, in particular an appellate lawyer, can have is careful listening skills. Listening to the words, listening to the content behind the words, listening to the currents between how people are interacting on the bench can do just wonders for your ability to respond intelligently and respond in a way that's going to be persuasive to the people who are deciding the case. I think you all made an excellent effort to do that today. It's a very difficult skill, and particularly when the lights are on and the cameras are here and the pressure's on, so to speak. So you're all to be congratulated. Thank you.
Yeah, there's not much else to say, although I do want to commend you, because I know you've only had this for 2 months. And there's lots of cases in there, and there's the facts that you have to memorize, and you knew it. You knew the cases when we asked you hard questions, and you had synthesized it very well, and knew what you were talking about. You should be very proud of yourselves, and I'm sure your family members are, and your advisors are. Congratulations, both of teams.
Thank you all, for the four of you, and all the other teams. 6 years ago, I was president of the state bar, and I suggested that maybe instead of just mock trial, we also have moot court. Now, I was not a justice, I was a judge, and I'm glad we do. Because it teaches a skill that if you never become a lawyer, you will have the skill to be able to stand up and answer questions, because all four of you listened to the questions. It doesn't happen all the time in the Supreme Court or Court of Appeals. So people don't always listen to the question, but you all did. And that other skill of standing up and answering those questions, say you never become a lawyer. What if you're at a community organization event or a zoning appeal, somebody's going to destroy your property, right? Pretty raucous. You got to stand up there in front of these people and answer questions and talk and describe things. It will benefit you so much the rest of your life, this ability that you've learned, this skill. And I think you all should be very happy with your abilities and very proud. I'm not going to give any individual points, but one thing I also want to say is you had a withering attack, all four of you. And that's actually what we're supposed to do. In real court, I've seen cases go where almost nothing's questioned. And I've seen other times where a person doesn't even get the first words out of their mouth and they get questioned. So on a scale of 1 to 10, the number of questions you got and the withering, I mean, every question went to the heart of your arguments. Nobody was beating around the bush, right? There weren't any softballs. In court, you'll sometimes see softballs thrown. Somebody's already kind of decided where they want the case to go, and they'll throw one side or the other a softball. That didn't happen here. You all handled it maturely, reasonably, politely, and civilly, and you all did a great job. I mean, I was way more impressed than I thought it was going to be this time, because it was such a difficult case for both sides. Thank you for participating. Please get others to participate. It's a great program. Thank you.